Case Digest on Qualified Trespass to Dwelling. People versus Marciano Medina, GR number L38417, December 16, 1933. Elements of Qualified Trespass to Dwelling. First, that offender is a private person. Second, that he enters the dwelling of another. Third, that such entrance is against the latter's will. Facts of the case. That on or about the 7th day of August 1932, in that of Parañaque, province of Rizal, Philippine Islands, Marciano Medina alias Mariano Medina alias Alejandro Dola, being a private individual, at nighttime, did there and then willfully, unlawfully, and feloniously entered the dwelling of Captain J.H. Davidson against the latter's will, by forcing his way through a window protected by wire screens, an opening not intended for entrance, and once inside the house, when his presence therein was detected by the inmates thereof who tried to put him under arrest. The said Marciano Medina, in resisting the arrest and thus being able to escape, with intent to kill Joseph Davidson, son of Captain Davidson. He did then and there willfully, unlawfully, and feloniously assault, attacked, and stabbed with an open knife said Joseph Davidson on the upper left chest, thus inflicting upon him a mortal wound penetrating the lungs, which would have produced his death as consequence, thus performing all the acts of execution which would produce the death of the said Joseph Davidson, by reason of cause independent of the will of the accused, that is, because of the timely and able medical aid given to the victim by Dr. Alexander Melou. The issue of the case, whether or not it is not proper to impose upon the accused the several penalties corresponding to the 3 crimes with which he was charged, that was only crime of which the defendant can be convicted in this case is less serious physical injuries. The Supreme Court held that when the defendant in a criminal cause goes to a trial under a complaint or information which contains a description of more than one offense, he thereby waives the objection and may be found guilty of, and should be sentenced for as many offenses as are charged in the complaint and proved during the trial. A failure to object for multifariousness in a complaint is a waiver, and that objection cannot be raised for the first time on the appeal. Citing People v. Miana, 50 Philippines 771. The essence of the plea of guilty in a criminal trial is that the accused on arraignment admits his guilt freely, voluntarily, and with full knowledge of the consequences and meaning of his act, and with a clear understanding of a precise nature of the crime or crimes charged in the complaint or information. Such a plea of guilty, when formally entered on arraignment, is sufficient to sustain a conviction of any offenses charged in the information, even the capital offense, without the introduction of further evidence, the defendant himself having supplied the necessary proof. The lower court find that 4 aggravating circumstances were present in the commission of the crime, and that the accused were entitled to the mitigating circumstance of having pleaded guilty. The lower court did not specify the 4 aggravating circumstances taking into account, although the unlawful entry, that is, the passing of the accused through a window, and the breaking of window could not properly be regarded as aggravating circumstances in the crime of trespass to dwelling. Nevertheless, the another aggravating circumstances were sufficient to justify the imposition of the maximum degree of the corresponding penalties. The decision of the lower court sentencing the defendant to suffer 4 months and 1 day of arresto mayor for lesiones menos graves is affirmed. In accordance with Articles 280 and 249 of the Revised Penal Code, In the Act 4103, the appellant is condemned to suffer the following indeterminate sentences. First, for the crime of trespass to dwelling by means of violence, not more than 4 years, 9 months, and 11 days of prison correctional, and of a fine of 200 pesos, or for the corresponding subsidiary imprisonment in case of insolvency, and not less than 2 years of prison correctional. Second, for the crime of frustrated homicide, not more than 10 years and 1 day of prison mayor, and not less than 5 years of prison correctional.